Hi, my name is Grace Ross, and I'm the coordinator of the Mass Alliance Against Predatory Lending. You can find us on the web at www.maapl.info. And I'm not an attorney. We do coordinate what most of the attorneys fighting on the side of homeowners and tenants against foreclosures are doing, which means we've got a lot of experience and information, but this is not legal advice. I'm not a lawyer, and I couldn't give you legal advice. There are a lot more resources on our website, and we do train lawyers in these areas if they're interested. I wanted to quickly go through the vast majority of people who are fighting for their homes have been wiped out financially by the foreclosure. They may have lost a job, they may have health issues that they didn't used to have, whatever it is. The vast majority of you are having to be in court defending yourselves against an eviction, or even in a proactive case, fighting the bank. So there's some basic legal concepts that I wanted to make sure that you can, in your mind, at least sort out. So often, folks who've never done any legal casework, a bunch of you have gone out and been reading everything you could find on the web. You've found a lot of information, or you may find information on our website about what was done that was illegal in your situation, and you're ready to fight, which is totally awesome. You need to think about what's going on in court, however, based on how a judge perceives it and what their role is, right? Because you're trying to get what you want from them. It helps for you to know what's going on their side. I always think of a judge like, say you meet a couple and you guys instantly like each other, and you decide to go drop by their house, and you go by the house and you knock on the door, and there isn't an answer, but the door is unlocked. You open it, and the two of them are yelling at each other. Literally, china plates are flying across the room and smashing against the walls, and you don't know them. You just met. You don't know who's likely to have started the fight, or what the fight's about, or who's right. That is generally where the judge enters the situation. The controversy's already heated, everybody's already throwing things at each other, and a judge is left to try and figure out what's going on. So in general, I encourage folks to recognize that whoever looks sanest in court, because the judge doesn't know who's right or who's wrong, they're going to have a natural tendency to believe whoever looks least crazy. And so some of that's how you physically appear and how you physically dress. But you're upset, right? One of your most fundamental rights in your life is on the line. The lawyer is trained to try and look cool no matter what happens. So somewhere in here you've got to find for yourself a place to stand with a certain amount of confidence and belief in yourself, conviction about the rightness of your cause, so that you can center yourself and be grounded in this really challenging situation, given both the court and what you're going through. If you get your facts right, what we know is overwhelmingly that banks broke the laws in millions of big and little ways. You can pretty quickly get a lawyer for the banks on the defensive. If you know your facts well and you can be comfortable, you would be surprised how often somebody who's not a lawyer, referred to as self-represented or pro se, can get the upper hand with the bank's lawyer. It happens a lot. If you can get yourself to a place, and we strongly encourage you to practice before you go to court. I know people hate role-playing, they hate talking as if they're somewhere where they're not and trying out what they're going to say, but it can make all the difference in the world. Oh, and don't go alone. Bring friends, family, somebody you pick up off the street who liked you. Don't go alone. Okay. So what I wanted to cover here is one of the conceptual things that people have the hardest time with. A judge determines two types of things. They determine what evidence they believe is credible, what evidence they think is accurate and truthful and factually correct, and they determine the legal interpretation of what happened. When you present, you need to separate those for a judge. What is a factual statement or factual evidence, and what is a legal argument? And in these cases, you are overwhelmingly in civil court, which means unlike those of us who've spent way too much time watching criminal trials on TV in in drama series or something like that. Criminal trial, they have to prove intent. You don't have to prove intent. In fact, the intent mostly doesn't matter in a civil case. So you may be furious, you may have read stuff, you may want to tell the judge that, Wells Fargo is on its, 15th major lawsuit, but that they're losing because of illegal activities they've been involved in. Not relevant. Because what matters for the judge is what happened in your specific case that you can prove through the evidence attached to legal arguments that are recognized, ideally long-term legal arguments. So what's the difference between a fact and a legal argument? To some extent, one could argue that all facts are being interpreted by the law. Is something a affidavit, right, a sworn statement or not? That's a legal interpretation because what qualifies as swearing to something is something that's a legal question. But those kinds of things have kind of been settled in law. So they're no longer seen as a legal question, they're really seen as what are the facts in the affidavit. So I like to think of facts as something that could end up in an affidavit. It's something that was seen, heard, smelled, touched, whatever. Something concrete that somebody can say, this is in fact what happened. So a legal document is what the court is most used to having. Obviously video evidence could qualify, an affidavit where you're swearing to what you saw could qualify. But the vast majority of what you're going to deal with are physical written documents. And if you remember the tape about real property law, all transfers in property have to happen in writing. So this particular area of law, and notes that are your debt that you signed is also literally in the physical paper itself. So transfers of property have to happen in writing, and your debt is in a physical piece of paper itself. So the paper itself is very important. So when you think about facts, you need to think about not what you think is important. You need to remember that the judge just walked into a fight and the plates, the china is flying back and forth. So if you start in the middle of your story and you drop them in the middle of the facts, they don't know what's going on. They don't know who you are, they don't know what your relationship is to the property, they don't know what your relationship is to whoever claims to be the bank and have the mortgage. They don't have any of that. So you may not in court recite the whole background, but in your written document you're going to want to lay out the facts from where the story begins. And the story begins, in these cases, with the fact, if you're the homeowner, that you own the property. You probably still own the property, but you want to start from the place of, I'm the homeowner, I got my property in whatever year it was, and then every step along the way, lay out the facts about what happened. You can do it in writing. You should turn it in writing. We have sample fact statements that you can get on our website and fill those in. Only fill in what you know to be true. You may well suspect that the person from the bank who gave you the runaround 12 times when you know you sent them your paperwork is doing something that was unfair, but you don't have proof that they were doing that. So you generally in these cases, they have so messed up so many things that you don't need to guess or make conjecture. The flip side of that is when you're stating a fact, don't make it sound like a guess. Don't say, Your Honor, I think that this affidavit isn't an affidavit. If you know that what the bank gave you as a sworn document was sworn by somebody who, for instance, was not at the auction because you've got a videotape and you know who was at the auction, don't say, well, Your Honor, I believe this document shows someone who didn't really have a right to swear to this affidavit. You may be trying to be respectful or deferential to the judge, which is a good posture to take towards the judge. If you act angry towards them or yell at them, you're probably not going to get the decision you want. But don't weaken the facts that you have. If you have evidence that such and such is true, say, Your Honor, the evidence shows this is true. The term I belief is actually a different legal standard. It's a weaker legal standard than a fact. So be careful about using a word that takes away from from the clarity of your factual evidence. The other side of things that a judge is responsible for is interpreting the law. Now, law is the way that a law is applied is determined by three things I can think of at the moment. One is the plain letter language of the law itself. Laws are supposed to be written and interpreted the way a reasonable person would assume they mean something. So if a law says, I'm not allowed to auction your property without having given you proper notice, for instance. If everybody thinks proper notice means actually getting a physical thing in the mail, not that somebody sent you a message over Facebook, then the law would interpret it as something you got by mail, because that's what a reasonable person, plain letter language, would interpret that to mean. A judge also interprets how a law is read based on how the courts have interpreted it in the past. Almost everything you're going to deal with these laws that the banks broke have been interpreted the same way for 150, 200 years, and it's only been in the last 15 or 20 years where the banks kind of went off the rails and decided all that mattered was making money, not what the laws were, that there have been any decisions that wouldn't back up your common sense understanding of what you're dealing with. So almost always the legal interpretation over time, which is referred to as jurisprudence, is on your side. The third way that they'll interpret a law, particularly if there are newer laws where there isn't much jurisprudence, is going to be based on what they refer to as the mind of the framers. Why did they pass this law? What was the purpose of it? In Massachusetts, that's interpreted very narrowly to be literally the language that was put into the law, the language that over the time that it took to pass the law was either added or subtracted. They assume that's intentional. So the interpretation of the mind of the framers is very narrowly interpreted in Massachusetts courts. So those are basically the bases of how a judge is going to look at something, and they're supposed to be interpreting things within that context. There's also a presumption that the legal rules of our society form an entire cloth, a whole cloth. So one law, if it's going to be interpreted and it's unclear, is not supposed to be interpreted in a way that makes it an outlier with how everything else around it is interpreted. That helps us a lot because the banks are often trying to take the way something's written and kind of warp it to meet what makes them win. And so if they warp something in such a way that it goes out of the norm of all the laws around it, then they're interpreting it wrong. And here's your plus. The foreclosure laws cross over 6 or 7 different areas of law. No lawyer or judge is an expert in all areas of law. They're like doctors, they specialize. And so they become experts in a particular area. Your case is not going to neatly stay within that area. It's not going to just be determined by tenant-landlord law, or just be determined by real property law, or just be determined by how notes, the Uniform Commercial Code, works, and I could keep going. It's a long list. Judge you're in front of will not know all the areas of law, but you, if you've learned the facts in your case, and you can logically explain how they're supposed to work, you've actually got an upper hand over the lawyer on the other side, who is going to stay within trying to say, well, this is the way it's been interpreted before, Your Honor, or this or that, and they may make it up or misinterpret it. You can say, Your Honor, there's no way that they can kick me out of my home if they can't prove they don't own it. You may not know all of the jurisprudence, all of the laws behind that, but it's logical. And our laws are supposed to form a whole that makes sense. So use your logic. And some of the best arguers I've ever heard who were not lawyers get really good at analogies that are accurate, and they can capture the conceptual thinking of the judge in a way that simply quoting a case or something like that does not. So legal interpretation, where facts end, is where legal interpretation begins. So if you say, Your Honor, this foreclosure deed has the following words in it, and those following words usually mean the following thing, and that means this foreclosure deed is not doing what it says. And here, Your Honor, is legally why that matters. Now, once you've got into that, you're going to have to look at a law, or you're going to have to look at a previous legal argument, a legal decision, hopefully from our top court, the SJC. and give the judge a reasoning that is based on legal interpretation. If you don't have it, use logic. If you then say to the judge, therefore, this deed is no good, that's fine. You walked the judge there, you got them to the legal conclusion you want them to get to. But if you're writing documents or you start out, you do not start out by telling the judge the conclusion they're supposed to come to. That's called a legal conclusion, and when you're in front of a judge, that's their job. It's not your job. Do not state for the judge a legal conclusion without first walking them through all the facts and all the legal argument that you've been able to find, because it's basically an insult to them. You're basically saying, I'm doing your job for you, and most judges don't take that kindly. So be careful not to state a legal conclusion. Give them all the evidence, walk them there, and then let them make the legal conclusion.